Our next speaker is Sean Boyle from Blake's in Canada. Quick footnote here. Sean is not giving out his home address. He has heard that there is a presidential election in a couple of weeks in the United States, and he knows that regardless of the outcome, 50% of all U.S. attendees he meets here this weekend will be knocking on his door trying to sleep on his couch. So you can get his work address, but his home address is not currently available. In commercial litigation today, the parties and the facts can increasingly cross the U.S. Canada border. However, if this is a situation that you face, this added complexity shouldn't hinder you from building your case or enforcing your judgment. Canadian courts frequently assist in collecting evidence for foreign proceedings, which is very Canadian, and thank you very much. And even address potential restrictions on derivative use of that evidence. And once a U.S. judgment is entered, Canadian legislation and the common law do generally allow for enforcement in Canada. Consequently, it's important to incorporate those concepts into your trial strategy as early as possible when Canadian evidence or Canadian assets are at stake. Please join me in welcoming from across the border, Sean Boyle.
Good morning. Thank you, Amy. I do bring greetings from our recently elected Prime Minister, Justin Trudeau, who was elected last year after the longest election in Canadian history, 11 weeks. True. As you will appreciate, the economies of U.S. and Canada are highly integrated. There's close ties between the individuals, the businesses, travel regularly between the two countries, at least for the time being. As Amy mentioned, there's an election here in 10 days, and that all may change. In particular, I have it on good authority from Prime Minister Trudeau that Canada may be building a wall. And you all are paying for it. Invariably, with the interactions of business and commerce, disputes arise, and then what? Today, I will be talking about collecting evidence and for your U.S. actions in Canada, and when you do have a judgment in the variety of states here in the United States of how you may go about enforcing that judgment in Canada. I believe letters rogatory is known to all of you, also sometimes known as letters of assistance. There's many reasons that U.S. litigants may need the help of the Canadian courts in their U.S. actions. Even if the dispute has nothing to do with Canada, one of the parties may have moved north, key witnesses might reside in Canada, or crucial documents may be found on servers within Canada or perhaps within corporations, either parent or subsidiary corporations in Canada. And we are seeing that, quite frankly, more and more, where for a variety of reasons, U.S. Companies are hosting their documents outside of the U.S. for a variety of reasons, both proper and improper. The Canadian Evidence Act provides specifically for the judicial assistance of foreign countries. It provides a process and a premise by which you can move forward. And I can say one of the takeaways for all of you today is that the process will run smoother if you obtain Canadian counsel's assistance early on before the request or the letter of rogatory are issued by the U.S. court. Within Canada, we have a number of provinces and territories. The law differs in each province and territory, but there are a number of common themes. This is really the legal portion of my presentation. The courts will assist your U.S. state courts or federal courts if really six hurdles are overcome. One, the evidence sought must be relevant. You will have to prove, with the assistance of your Canadian counsel, that the evidence is necessary for trial and will be adduced if relevant. So what our courts don't want is fishing expeditions with our Canadian citizens and our Canadian corporations. You have to prove that it's relevant and is necessary for trial. You have to adduce evidence as to whether the evidence is otherwise attainable. Are there other sources that you could gather the evidence without putting the Canadian courts and the Canadian citizens through the process of compelling their testimony? Fourth, whether the order sought is contrary to public policy, whether there are any issues relating to the litigation in the U.S. that would be contrary to Canadian public policy such that our courts will not grant assistance to you or your clients. Fifthly, whether the documents sought are identified with reasonable specificity. And this is actually one area that we see a lot of challenges to when we're dealing with letters rogatory or letters of assistance arising out of the U.S. What's really required is either the specific documents or the class of documents that you're seeking to obtain from a Canadian corporation are identified with specificity. And I make the point that it can be a class of documents. The court, again, just wants to be satisfied that this is not just an absolute fishing expedition that its citizens are being put through. And then finally, the sixth indicia is whether the order would be unduly burdensome. And that's really just a weighing of the equities of the whole process. One difference may be that throughout Canada and the different jurisdictions, there is what we call an implied undertaking as to confidentiality. And I say it's implied because that's the history of it. Some of the jurisdictions, some of the provinces now have a statutory requirement for confidentiality. And really what that is that the documents or information that you're seeking, there's a restriction on its use. And the restriction generally is for use at trial or legitimately in the court process. And what can't happen is the documents that you're obtaining can't be then used for another parallel litigation or for any purposes outside of that. And so I know on the recent news, to keep with the election theme, we've seen some depositions released to the media and things like that. That would be contrary to Canadian law and would result in sanctions. One of the important points on this duty is actually to the court and not to the other parties. And so if this is breached, if the deposition transcripts that were obtained through a letters of request in Canada were leaked and were used for other purposes and put on the internet or something like that, that potentially would be a breach of the Canadian court order and contempt proceedings, either civil contempt or criminal contempt process could be brought. So this is something the Canadian court takes quite seriously. So this is, I guess, the final point on letters rogatory. It is actually increasingly common. It is a regular matter to have depositions taking place throughout the various jurisdictions in Canada, whether regulatory authorities like the SEC or civil commercial litigation. It's a common process that our courts are quite familiar with. And if along as the letters of request, the letters of assistance arising out of the U.S. courts meet those 6 indicia, which I've identified and are in the materials that you have, the courts are quite willing to grant that assistance as a matter of international comity. Once you've obtained your judgment in the U.S., once there's a final judgment, once the time for appeal has expired, the Canadian courts again will offer assistance with enforcing your U.S. judgment. One of the first steps we would recommend before you take any steps to have that enforced is obviously to do a search as to the location, the jurisdiction of the defendant or of the entity you're seeking to enforce the judgment against, and more importantly, if it's a monetary judgment, to have some searches done through the Canadian resources to ensure they have assets that are exigible, that again the clients are not throwing good money after bad. Once that's done, there are a number of mechanisms under Canadian law that are very similar to what you would find throughout the various states. The examination and aid of execution, really an examination of the debtor, where they're required to come in very similar to a deposition, give evidence under oath as to the financial circumstance, bank accounts, investments, various assets, and that would be done under oath and before a court reporter. Additionally, there's the garnishment proceedings where the judgment of the U.S. court, once it's enforced, you could garnish the bank accounts and put liens and seize other assets of the debtor. The recognition process is really, there's two routes to recognition. The first is the Reciprocal Enforcement Act. It's the statutory route that a variety of the provinces have. And I understand from speaking with many of you this weekend that that is a very similar process to domesticating a judgment, that the considerations under the relevant statutes are very similar. One, you have a certified copy of your final judgment. The time for appeal has passed. There is some evidence or proof that the defendant had notice, even better if they defend it. Just some of those basic natural justice, procedural fairness indicia are met, that under the various statutes of the relevant provinces, that judgment would be recognized in a quite efficient and inexpensive manner. Specifically, the provinces out west where I'm from Vancouver, British Columbia. British Columbia and Alberta have what we call recognition of reciprocating jurisdictions. And those typically have some geographical connection: Alaska, California, Colorado, Idaho, Washington State, Montana, so on and so forth. And those states actually have agreements with the Canadian provinces where they will recognize our judgments should we get judgment against someone in Alaska, for example, or Colorado, and likewise we'll recognize their judgment. And I gather it's a very summary process that you can go through, very similar to domesticating a judgment. For the other provinces, and in particular it's noteworthy for Ontario, does not have those sorts of reciprocating agreements. And so if you want to enforce your U.S. judgment in Ontario, maybe there's a debtor in Toronto, our largest city, you would have to go the common law route. The common law is very similar to what you might expect here. Really, you have to sue on the judgment. And so you would commence a notice of civil claim, a complaint in your parlance, and prove again that there was notice, there was service, that judgment was rendered, and the time for appeal has passed. It is also a summary process. But it is much lengthier than the simply domesticating a judgment with a reciprocating jurisdiction. In that case, you'll have to prove that the U.S. court had a real and substantial connection to the action in the parties, and again, that the processes of procedural fairness were followed. It is quite common, again, that those judgments will be recognized out of the U.S. Recently, we've had some major litigation in Canada arising out of Ecuador with the Chevron decision that you may be familiar with here. They're looking to register their $9 billion claim against Chevron, which of course has a presence in Canada, in particular in Alberta in our oil and gas industry. And so that has worked its way up to the Canadian Supreme Court and is really creating some new law there. It was remanded back, and so there is a decision that's under consideration. And so that may change things, and our courts are struggling with how to deal with these the international component of it. The other part, just for interest's sake, is we're seeing a lot is, again, like Chevron, Ecuador, all our natural resource companies that parents are located in Canada or the U.S., and they have operations in Africa or Central America, where plaintiffs' counsel locally want to sue for the actions of a subsidiary in a foreign country, whether it be environmental issues or other treatment of workers. And so, again, our courts have been dealing with that and struggling with it. If a common law action is brought to enforce the judgment, there are a number of defenses. Again, I think defenses that you would find familiar when you're looking to domesticate a judgment. Obviously, if the underlying trial, there was some sort of fraud involved by one of the parties, that new evidence came out, that would be an issue where our courts would not recognize that judgment. A more common one, though, is actually the third point, the lack of natural justice, that somehow there was a failure to give notice to an interested party, somehow there was a lack of an opportunity to be heard. Again, quite rare for U.S. judgments, but more common and arises in our case law when we're looking, obviously, at other foreign countries that are trying to enforce judgments. That being said, as you can all appreciate, still quite common for a debtor to raise these arguments, even if they have no grounds whatsoever. That somehow a state court judge, there was a lack of procedural fairness, whatever sort of bias argument they can raise, they are usually unsuccessful, but of course what happens is they delay the process, create further expense, and possibly are used as a tool to negotiate settlement. So it should not come as a surprise. Really, the takeaway, quite obviously, is a brief phone call before you go to the U.S. court to get your letters of request. It is quite frankly quite common, and I deal with these a lot from different jurisdictions, and have quite an interesting one from Russia going on right now. That hour of time to get the input from Canadian counsel before you get the letter of request, because once the letter of request comes out of the New York court or whatever it is, we're usually stuck with it, and it can make it a little more difficult, a little more expensive going through the process to get that dealt with. The other real takeaway, in addition to getting your Canadian counsel involved early, is, and it ties into the first one, is get the assistance to determine whether it's worth it, whether it's worth the expense and effort of going to enforce that judgment in Canada, whether it's worth the expense and effort of looking to obtain those depositions. There's a number of public databases, just as you would find throughout the United States, where we can search to see what sort of assets do the debtors have or do the individuals have, what kind of jeopardy can we put them in, and whether they in particular own real property that a lien, or as we call sometimes a certificate of pending litigation, a lien that can be put onto their properties to protect your client's interests. And maybe most importantly, while I'm talking to all of you in the private practice, one of the other things we see in Canada is if you happen to have your Canadian clients, and for whatever reason they look to stiff you on your bill, you sue them in your home state, wherever you provided the legal services, they've a torn to your jurisdiction, and it may provide you some comfort that there is an inexpensive and easy process to enforce your judgment in those circumstances. Thank you very much.